Welcome. My name is June Casey, and I welcome you here to our first book talk for the spring semester. We are here to celebrate Lessons in Censorship, How Schools and Courts Subvert Students' First Amendment Rights, published recently by the Harvard University Press, and also awarded the honor of being the best book on the First Amendment of 2015 by the First Amendment News of Concurring Opinions. We are here to honor this book, and we have author Professor Catherine Ross with us today. Professor Ross is visiting scholar in education at the Harvard Graduate School of Education and also is professor of law at George Washington University. Joining Professor Ross, we have our Harvard Law School panelists, Professor Mark Tushnet, who is the William Nelson Cromwell Professor of Law. We have visiting Professor Paul Horwitz, who is Gordon Rosen Professor of Law at the University of Alabama School of Law. And we also have Clinical Professor of Law Michael Gregory, where he teaches law as part of the Trauma and Learning Policy Initiative. I also want to let you know, if you have friends who were not able to make it to today's book talk, that Professor Ross will also be speaking at the Harvard Bookstore on Friday the 26th at 3 p.m., also about lessons in censorship. For those of you who will be asking questions at the end of our book talk, I also want to let you know that today's session is going to be recorded, and if you would like to rewatch the talk, we release the talks on YouTube about 2 weeks out after today's event. Also, before we get started, I just want to let you know that we are joined today by the Harvard Coop, who is in the back of the room selling copies of Lessons in Censorship for you. So again, thank you for joining us today, and Professor Ross, I will hand it over to you.
Thank you so much, June, for inviting me and for your gracious introduction. It's really a pleasure to be here, and I thank all of you for coming. I also want to mention my editor at Harvard Press, Mike Aronson, who has amazingly not heard enough about this book yet and is here with us today. And thank you to Mark, Mike, and Paul for participating in this panel. In keeping with what I understand to be the norms of these occasions, I'm not going to give a formal prepared talk, but I rather want to just share some thoughts about my book and give you some signposts for those who have not yet read it, which I assume is almost everybody in the room. So, why did I write the book? As one example, Guido Calabresi, who is no intellectual shrinking violet, has implied that school speech doctrine is as hazardous as Ulysses' journey between Scylla and Charybdis, referring to unsettled waters rife with rocky shoals and uncertain currents. He suggests, along with Justice Breyer and many other lower court judges, that the doctrine has become so difficult to understand and so convoluted that it fails to perform its guidance function, in what might appear to be a perfect illustration of Mark Tushnet's comments on the complexities that result from the doctrinalization of free speech, that the doctrine essentially sinks of its own weight. I began my book in response to this widespread confusion and to tackle what I saw as rampant disregard of constitutional rights, disregard both at the ground level, what the schools were actually doing, and in many lower court decisions. So what kind of speech am I talking about? Censorship cuts across every political, philosophical, and value system. Students express their views on matters of public concern, like civil rights, war and peace, both sides of the debates over abortion and the rights of LGBTs. They proselytize. They support and condemn candidates for public office. All of these are at the apex of valuable speech, and yet schools have silenced all of them out of ignorance, indifference, and or disdain for the law. Like the rest of us, students also have what the court has called the freedom to speak foolishly and without moderation, as witnessed in expression many adults condemn, like verbal bullying without violence, sexting, and speech disparaging minority groups, as well as adolescent humor beyond adult comprehension. As I thought about this array of problems, I had several goals in mind. The first was to analyze and clarify the existing law, providing guidance on what the doctrine actually means, and identifying the many subsidiary questions the Supreme Court is unlikely ever to answer. For each kind of student speech, I set out what the law is, where it remains unclear, And in many or most instances, I try to suggest ways of better protecting student rights within the existing framework, which brings me to my second goal, which is to propose a coherent and easily understandable approach that rests on existing doctrine, in other words, doesn't totally discard it, and that protects student expression without disrupting education. I've set out my intellectual motives, so let me summarize 3 themes that run through the book. First, the continuing culture wars that play out in schools, which have at their core disputes both over the balance between authority and individual rights and reflect profound divisions in the values that children learn at home, which have their own source of constitutional protection. Second, over the last half-century, each Chief Justice's court took up one student speech case, resulting in the continued diminution of speech rights for students over time as the court became more conservative. No surprise to most of you in this room, but important to explain to other readers who are not lawyers, and to some lawyers as well. Third, the school's abdication of its role that has been played since the early republic in fostering democracy. The failure to model speech rights by honoring them and to show that the state means what it says about liberty imperils participatory democracy and promotes the acceptance of the notion that the state is all-powerful. The perception that the state is all-powerful has been enhanced over the last decade as schools increasingly reach out to punish speech that takes place off campus and online, and over which I argue the school has no jurisdiction at all. So why does all this matter? The First Amendment protects controversial, offensive, and disputative speech. And by censoring and punishing protected speech, I argue, the schools not only violate the rights of individual students, they undermine our constitutional norms. Schools are our best chance to inculcate citizens in what the Constitution means and why we have to respect each other's rights. About 90% of American children today still go to public school. But as one student told a reporter, my school is all about censorship. The first 2 chapters of my book situate the quintet of Supreme Court cases on student speech in the framework of First Amendment jurisprudence as it existed when each student speech case was decided. And this is important because student rights were not an afterthought to the doctrine of free speech. This is clear from Justice Jackson's 1943 opinion in West Virginia versus Barnett. Barnett was one of the court's earliest statements about why First Amendment freedoms matter and what they mean to appear in a majority opinion that actually held for the speaker. The opinion set out a number of principles key to my project, and here I'm just cherry-picking what I need to tell you today. The court ruled that the speech clause applies to public school students. The successful petitioners, Jehovah's Witnesses at risk of expulsion and delinquency proceedings because they refused to say the Pledge of Allegiance, were elementary school students. The Barnett Court made clear that its holding rested on limits to the state's authority, was based in the speech clause, not the religion clauses, and applied to all nonconformists regardless of the source of their beliefs. And finally, the court said if there were a hierarchy of speakers and their rights, which there is not, the rights of students should be at the highest level. Here, Justice Jackson was at his most eloquent. That boards of education are educating the young for citizenship is reason for scrupulous protection of the individual if we are not to strangle the free mind at its source and teach youth to discount important principles of government as mere platitudes. Several decades later, the court began to carve out a special approach to student speech. And for those of you who may not be familiar with it, I will give a simple, really oversimplified overview of the jurisprudence that governs speech in public schools K through 12. And that was set forth starting in 1969 in Tinker versus Des Moines, and Professor Field was Justice Fortas's clerk when he authored the opinion for the court. So we have really quite an amazing audience today. The doctrine set out in Justice Fortas's opinion, and I note he also authored In Re Gault, which transformed the juvenile justice system for the modern world. And he set out a unique test for assessing the constitutionality of school censorship in light of the special characteristics of the school environment, including the school's uniquely important role in training young people to assume the mantle of citizenship. In Tinker, students had challenged their suspension for wearing black armbands to protest the Vietnam War, and they won. The court ruled the school district had violated their rights and crafted a new rule. Schools may not restrict student speech unless officials can show they reasonably anticipate that the expression will materially disrupt education or collide with the rights of others. The essence of Tinker answers the most serious criticisms that have been levied against it, because Tinker means that the school always has the right to silence speech that it fears will lead to violence or even to the level of disorder that will make it impossible to conduct classes and continue the school's educational mission. Though it never overruled Tinker, the court gradually carved out exceptions to this material disruption test. The three exceptions created a taxonomy of speech rights that remains in place today. The most important exception in terms of the number of cases reached and the scope of speech silenced is that if the speech appears to bear the school's imprimatur, and if it takes place in activity related to the curriculum, which includes almost every school publication and most extracurricular activities, it's characterized as school-sponsored. In other words, what Justice Alito called the school's own speech. It ceases to be understood as the student's speech, even though it emanates from the student. And schools may regulate this speech for any legitimate pedagogical reason under Hazelwood v. Kohlmeyer. There are two more exceptions that affect many fewer cases. Under Bethel v. Frazier, the school may restrict lewd speech as part of their civilizing function entirely at their discretion. And finally, in the most recent case, Frederick versus Morse, which you may know as the Bong Hits for Jesus banner case, the court held that schools may censor speech that appear to advocate the use of illegal substances, with the caveat that Justice Breyer, who provided the fifth vote, said schools cannot censor political speech under this standard. So this taxonomy continues to govern when schools may permissibly silence student speech through either prior restraint or penalties imposed after the fact. And the penalties can be very serious, ranging from short-term suspension to expulsion for the rest of the school year, to assignment to alternative schools for seriously disturbed students. And these penalties are well known to often lead young people to embark on the school-to-prison pipeline. But Tinker continues to govern what I call pure student speech, personal expression that does not trigger one of the other exceptions. So this categorization matters enormously because it determines the standard of review if the student brings a lawsuit, and of course most students don't because the disincentives to doing so are profound, and therefore also determines whether the school or the student is going to win in most instances. So how do the courts actually use these standards? And how do the schools regard them? Well, educators have pushed the boundaries of every case that gives them more discretion than Tinker to colonize other forms of speech. So, for example, although Frazier is properly limited to speech with sexual overtones, schools argue that it allows them to punish all manner of impudence, cursing, and words that offend social norms, including all criticisms levied at teachers. Now, to briefly address only the last, and I'm glad some of you laughed because it is risible, criticism of authority is not only a characteristic of adolescence, it's an essential aspect of democratic citizenship, whether directed to a president, a team's coach, a teacher, or a school principal. With respect to Hazelwood, schools increasingly claim that a student's own comments in classroom discussion and in assignments handed in only to the teacher are school-sponsored speech, even though this expression could not possibly satisfy any reasonable observer's idea that it has the school's imprimatur. Nobody knew what the student was going to say. The school couldn't have approved it. This development poses a very serious risk to intellectual inquiry because teachers in most circuits are not allowed to provide alternatives to the approved curriculum. Think of biology classes and sex ed classes, as well as American history classes. And so that restriction on teachers' speech rights in high schools and elementary schools leaves students as the sole source of intellectual dissent in many of the nation's classrooms. Finally, in the last section of my book, I delve deeper into Tinker, explicating the meaning of disruption and of the rights of others, which I demonstrate never stands on its own to justify censorship, and applying its doctrine to several pressing contemporary speech problems, demonstrating Tinker's continued vitality and relevance. Before turning this discussion over to the commentators, I just want to say a few words about one contemporary problem, which has become even more central to public debate since I completed my manuscript about 14 months ago. The question of whether the Constitution permits schools to regulate hurtful speech addressed to groups or individuals. And here's the crowning paradox. Does a liberal secular democracy that strives to inculcate tolerance and mutual respect have to tolerate the expression of intolerance? Under our Constitution, the answer is yes. I'll use racial slurs and the frequently litigated personal display of the Confederate flag as an example of the context-based analysis that Tinker requires. And I suspect Paul will have something to say about context-based analysis. A particular school may not bar racist speech unless that school and that community have a history of disruption based on racial conflict, because such a history supports the school's claim that it anticipates a risk of material disruption. But schools that have a history of amicable race relationships must permit the personal display of symbols like the Confederate flag and even the use of offensive words. When Justice Kagan was a law professor considering the constitutionality of hate speech codes in universities, she wrote, "A reasonable system of First Amendment law would allow an exceedingly narrow speech code aimed at discriminatory harassment, but it can't survive constitutional analysis in the U.S. No matter how well-intentioned, school hate speech codes must be limited to speech that would violate either civil or criminal harassment codes if they're to avoid trampling on speech rights." Justice Alito may have gone even further when he sat on the Third Circuit, pointing out there's no right to be protected from hurtful words because there's a real tension between anti-harassment laws and freedom of expression. Moreover, school officials confronted with group disparagement have too often turned First Amendment doctrine on its head, revealing an extreme heckler's veto problem. Schools have removed the speakers whose ideas offend a group, rather than protecting the speaker from the mob. Now, they say they're doing it to protect the speaker from violence, but there are many other things they could try first. Removal is not always short-term. In one case, the student, who actually just repeated a comment he had heard from somebody else, not approving it, was suspended for the entire year, and the next year had to move to a distant state. This violates the speaker's expressive rights, and it wrongly gives listeners the power to censor, a situation at odds with every building block of our speech clause. So paternalistic authorities in schools too often convey to their students that they can expect to be sheltered from wounding words. And these experiences may influence the expectations that underlie some of the current demands to constrain offensive but protected expression on college campuses, and I'll be happy to talk about that during the question period. Thank you.
Thank you so much. I'm delighted everybody is here. I'm thrilled to be here myself. I should say through kind of odd circumstances, I ended up taking an evidence course with Professor Ross when I was after being a student, when I was a practicing lawyer, and given her suggesting that I speak about context, it's clear that students should be aware of this. Even after you graduate, your professors are still calling on you, so be warned. This is a wonderful book. I've been thrilled to spend time with it over the last few weeks, and I think its signal virtue, there are many, but its signal virtue is its clarity, and if you come through the book without the sense that there is a clear scheme or plan in mind, it's not her doing. The lack of clarity must lie elsewhere, and I think maybe importantly so, and that's kind of what my little musing today will be about. So at the beginning of the book and at the beginning of her discussion, Professor Ross relates three dramatic stories that she says run through the book. The first, the entanglement of law and culture wars playing out in the schools. The second, divisions on the Supreme Court over jurisprudence, over First Amendment jurisprudence about education in public schools. And the third, the frequent failure of schools to perform the critical function of fostering the free exchange of ideas so essential to preserving a vital democracy. In reading the book, and we all, for many reasons, like to knock around the court's doctrine and the problems it causes. But in reading the book, my ultimate sense is that number two, the second factor, doesn't actually right now have as much to do with the problems in this area as the first and third factors, the culture war factor and the failure of schools to perform this function of fostering the free exchange of ideas that we see as core to vital democracy, citizenship, and so on. It's the relationship between those two, I think, that is causing the uncertainty and that I think will continue for some time. So we can imagine two. Well, let's describe that kind of idea of democracy and how it functions, right? So first, we could look at the classic quote by Justice Jackson in the Barnett case. If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. So there's a core First Amendment vision, still important, valuably criticized and explored by my friend Stephen Smith in a wonderful article called Barnett's Big Blunder, but still an important value. And to that we might add the words of Justice Brandeis concurring in the case of Whitney versus California. And there, in a remarkable passage, he talks about the value of civic courage, not just the importance of free speech for the subjects raised or for its contribution to truth-seeking, but because engaging in vigorous speech and counter-speech is itself formative of the kinds of virtues that we want and perhaps require of individual citizens in a democratic republic. Well, we can imagine two kinds of departures from this ideal. One is, roughly speaking, on the right. You can imagine individual schools, individual school districts where there is an orthodoxy, perhaps a patriotic orthodoxy, perhaps a religious orthodoxy, perhaps a conservative orthodoxy, or maybe a particularly stringent and traditionalist sense of what civility demands, and one that ends up having implications for students trying to raise new issues, express identities or ideas that have not previously been expressed. Maybe it's a function of the fact that I spend most of my time in universities rather than kind of in particular counties that are isolated from legal enforcement in some ways. Many of my students at Alabama have had that kind of experience. But I guess I see these as outlier cases not in the sense that they might not be numerous and important, but in the sense that I don't think they're driving a mainstream discussion about changing or revising that idea of orthodoxy. Then we can imagine something like, roughly speaking, a left critique of this kind of vision of orthodoxy or civic courage or virtue. That, I think, is relevant, is in the mix and in the discussion right now. And I'm not criticizing it. I have my concerns about it, but my point is just to describe why people might be hesitant about the virtues of the Tinker approach or of the values that underlie it. We might think that in order to be an incubator of civic virtue, public schools need to provide the preconditions for exercising civic virtue later in life, and that includes safety, security, freedom from harm or harm to dignity, right? All of which people might argue are going to be developmentally harmful as well as injurious. We can imagine questions about civic courage, and I think they have been raised and intelligently raised, in the sense that one might worry that demanding civic courage of individual citizens ends up having a kind of a disparate impact, where the burden of shouldering that view of civic courage is going to fall on those who are already most vulnerable, most subject to harm. Now, there happens to be, I think, a tremendous countervailing benefit in learning the values of civic courage, but still we should not discount that idea. Broadened definitions of harm, another way in which we might again question the model of fostering civic virtue or incubating civic virtue, particularly one that is linked to the idea of dignity, of individual dignity. And finally, arguments about what and when speech should be attributed to the government rather than to private individuals. So to the extent that you take the view that the public school is in part an environment, not a home, but a kind of a home away from home, and then to the extent that you have that kind of vigorous, possibly insulting speech in the schools, I think some now, increasingly, would argue that the school ought to be responsible for it, and that the failure to address it is itself something that should be attributed to the school. So I think, in short, that these we can all think of as culture war issues, in a sense, but to say so is not to deride them, and it seems that these are strongly linked to broader debates about what citizenship requires, about what the environment for the exercise of civic virtue should be, and about how we understand some of the background assumptions about the individuals who engage in the speech and the extent to which they should be helped, succored, preserved, protected, and so on. So ultimately, reading the book makes me think a lot about, obviously, the current campus conflicts. And I wanted to suggest that one way we might think about the book, and maybe about what's going on in public schools right now, is that they can serve as a kind of a natural experiment, a laboratory in thinking about what a thicker, more, again, I don't mean it derisively, a more safety-oriented, more community-oriented perspective on some of these issues about citizenship and what is needed to develop and protect it, what that kind of vision looks like when it plays out through the law. I think there's plenty of reason in Professor Ross's book to be concerned, to say that there are going to be real issues, problems, if we take that vision, and that the public schools, which in a sense have already taken that further step because they already have a different protective role and a more vulnerable audience, and that's recognized in law. The public schools have not always administered that thicker vision consistently, fairly, effectively, and that there have been costs to the larger vision of civic courage. But I also came away ultimately, and this is my last remark, with renewed and to me maybe somewhat surprising respect for and here thinking about campuses rather than public schools, for administrators, for university administrators, sometimes criticized from the kind of either conservative or civil libertarian perspective for giving in too much. But in reading through the book and thinking about it and seeing the travails of the public school administrators, one may have a greater sense of respect for both the difficulty they have in navigating an environment where the very idea of citizenship is under contestation right now and its requirements, and trying to work together, make positive value statements, while perhaps trying to preserve some of the important ground norms and rules of free speech in the university environment. So it was food for thought in that sense.
Good afternoon, everybody. I just have a few slides to illustrate a couple of the ideas that I want to talk about, so please indulge me in that. I want to begin by thanking Professor Ross for her work and for sharing it with us today. I teach education law and policy here at the law school, and so in that context, talk a lot about the role of public education in our democratic society, and believe strongly, in line with Justice Jackson, as you reminded us, that the central purpose of schools is to prepare us to participate effectively in the democratic process. So I find exceedingly valuable Professor Ross's analysis of how educators' typical responses to student speech often teach implicit lessons that undermine the vigor of the First Amendment, and in doing this, threaten to fray one of the most important threads in the fabric of our democracy. So thank you very much for undertaking this project. My own work involves teaching law students to represent families of students with disabilities in the special education system, and also teaching them the skills of legislative lawyering as they advocate for laws and policies that promote safe and supportive school environments. So the aspect of today's problem, the subversion of students' First Amendment rights, that I encounter most in my work is what Professor Ross calls words that harm, or hurtful speech, bullying, harassment. She devotes a chapter of her book to analyzing the problem of hurtful speech and whether and when and how it infringes on the rights of others and/or materially disrupts the educational process. Now, sometimes my clients are the targets of hurtful speech. Sometimes they are the speakers. Often they're both. And all of the educators I work with are highly concerned about how to prevent harm to their students without censoring their speech, and what to do about that speech when it is uttered in the school environment. So I'll focus my brief remarks on this particular problem, which is just one of the many problems, as you've heard, that Professor Ross tackles in her book. I'll also pick up the suggestion of Professor Horwitz to talk a little bit about the community and safety orientation as a vision of schools. I think you'll see that the ideas I want to share are very much in that vein. So I want to briefly explain why I find Professor Ross's argument, which is that, quote, the rights of others rubric alone never provides a sufficient rationale for censoring student speech, no matter how unpleasant, and that censorship is justified, quote, only when accompanied by a reasonable apprehension of material disorder, is a helpful argument, not only for preserving students' constitutional speech rights, but also for helping educators minimize hurtful speech in schools. So to show you why I find her argument helpful, I'm going to discuss three main ideas. Those are, first, that bullying is the symptom of a culture. It's not primarily just the actions of an individual student. Secondly, learning requires safety. And finally, it's not about the response. If what we want to do is prevent hurtful speech, it's not the response where we should be focusing all of our attention. So to illustrate the first of these ideas, that bullying is the symptom of a culture and not the actions of an individual, I'm going to share a metaphor, or an example, really, it's not a metaphor, from another context that's outside of law and outside of schools. In fact, it's football. So as a New England Patriots fan, I was, of course, overwhelmingly pleased with the outcome of last year's Super Bowl. And for those of you that are football fans, you know what happened at the end of that Super Bowl, which is that there was, in the waning seconds, when the opposing team was on the goal line and just about to score, this heroic play that Malcolm Butler did. He intercepted a pass, and in doing so, secured the victory for the Patriots, their 4th Super Bowl. It was amazing. Now, in analyzing that play, what the commentary initially focused on was the sheer athleticism and brilliance of the player who made the interception. And without a doubt, it was an amazing display of athleticism. But as the commentary continued, and for those of us who obsessively watched every single thing we could about the analysis of the game, it became clear that the team had practiced that very play over and over again in practice leading up to the championship game. And so it wasn't just that the player was brilliant in the moment, but his team, his coaches had prepared him to intercept that ball on that play. When you step back even further, what you understand is that the Patriots have a culture about the way they prepare for games. Their coaches have them practice what they call situational football. It's taking those circumstances where the players are going to have to react quickly, where they're not going to be able to stop and analyze and really understand what to do. They're going to practice those situations over and over again in practice. And when you step back even further, what you see is that it takes a certain kind of player to do well in that kind of system. It takes players who aren't just physically strong and have athletic prowess, but that have some intelligence, that have some cognitive ability to prepare in that way. And so when you step back, what you see is that it's really not just about that play that took milliseconds at the end of a game, but the reason that play could happen was because there was a whole culture that preceded it and that produced, in concert with the individual actions of the player, that result. Well, this is the same way that we need to look at bullying, or really anything that happens in a school. There's a culture that precedes any hurtful speech that occurs in a school, that precedes any incident between two students or groups of students. And if we want to prevent bullying, we need to look not just at the individual interactions, but we need to look at the culture that precedes and surrounds it. And I was going to show a clip of the Super Bowl, but we don't have time, and I won't subject you to that. Let's just get on to the second idea, which is that learning requires safety. So since the days when Tinker was decided, we've had advances in neurobiological and even epigenetic research that helps, I think, us expand the concept of what a material disruption would be or could be. The speech we should be concerned about is not just speech that interferes with the adult's ability to maintain the orderly functioning of the school day, which is probably something closer to what the Tinker Court had in mind. It's not just about keeping the trains running on time. We must be concerned about speech that makes students' brains less available for learning because it triggers the fight, flight, or freeze response in their bodies. Speech that activates their reptilian brains, their amygdalas and their limbic systems, and deactivates the parts of their brain necessary for academic and social learning, their frontal cortex. In short, science now explains to us that when students are in danger, whether that's real or perceived, when they are threatened and don't feel safe, they cannot learn effectively. And I think there's a parallel here to pick up on Professor Horwitz's point about some of the discussions we've been having on this campus in recent weeks and months and over the past couple of years. Though the court in Tinker couldn't have known this, except intuitively at the time because the science wasn't there, speech that triggers this response in students is materially disrupting the educational process, even if everything seems to be running smoothly on the surface. A culture that produces acts of bullying, to go back to idea number one, is a culture that undermines student learning. Not just the students who are the targets of the hurtful speech, by the way, but also the students who are bystanders and whose safety may be threatened by witnessing the victimization of a classmate. And also, incidentally, the learning of the bullies themselves. When adults do not hold children and keep them safe, which means both protecting them from the aggressive behavior of others and setting limits on and redirecting their own aggressive or antisocial behaviors, everyone's learning suffers. Rather than allowing a culture to form in a school that produces acts of bullying, it is the job of educators to work proactively to create safe and supportive cultures in schools where learning can flourish, sort of like creating a football team that knows what to do in the waning seconds of a Super Bowl. Third idea, it's about the response. When we find ourselves in the position of figuring out how to respond to hurtful speech that has already been uttered, it's too late. Yes, there is an affirmative duty, not a legal one perhaps, but a moral and professional one certainly, that educators have to repair the breach in the social contract that occurs when an incident of bullying happens, and to reestablish the sense of safety for all students so that everyone's learning can continue. But the utility of any response after the fact, if all of the culture building and prevention work has not already happened, will be marginal. All the more reason why punitive responses that infringe on students' free speech rights are not the way to go. Not only are they unconstitutional, as you've helped remind us, they are also educationally inadequate. In any kind of balancing test, their value would be nil. From an educator's point of view, the function, it seems to me, of Professor Ross's argument is to take off the table a set of options, censorship and punishment, that fail on both counts, constitutionally and educationally, pedagogically. Her argument sends educators back to the drawing board and says, you have to figure out another way. This is important and helpful because, in my view, it creates the possibility that we will place emphasis back where it needs to be, on the front end, on prevention, and it places emphasis not merely on the individual rights of other students, which are important, but also on the quality of the environment for all students. On building school cultures where everyone knows what hurtful speech is, where everyone buys in to a set of norms that value community, cohesion, pluralism, and respect, and where everyone is taught the skills to know what to do and how the adults will respond when those norms are inevitably violated, as they will be when you're talking about kids. This approach to hurtful speech is more difficult because it must be planful and proactive, and because it takes more time. But it is both more effective than censorship and punishment at preserving each student's access to educational opportunity, and more likely to produce the kind of citizens who will be prepared to participate effectively in the democracy that we aspire to be. Thanks.
Thank you. I found reading the book extremely interesting and, as these earlier comments indicated, thought-provoking. Given the panel in particular, I sort of welcome the opportunity to be relatively conservative about these issues. I can give you an account of why that is, but what I mean by relatively conservative is, roughly speaking, the book is full of examples from the lower courts and from unlitigated cases that get settled, and which I found extremely interesting. The set of cases extremely interesting. They, for rough purposes, fall into three categories. There are the cases where the school administrators or system behave in an outrageous kind of way. There are cases that are close questions, and there are cases where the schools are probably right. So being relatively conservative relative to the book is that Professor Ross thinks that there are a lot of cases in the outrageous category, and fewer in the close questions, and even fewer in the probably right category. As I read the examples, my juices don't get boiling over nearly as many cases as hers do. There are some outrages for me, I agree, but not as many as for her. There are many more close questions, and there are not many more cases that are probably right. So what can I say sort of analytically about this? Well, as everybody acknowledges, Professor Ross, the courts, the Supreme Court, schools have a role in educating for civic participation. And what that means is that they can, if they want, they don't have to, but we seem to think they should, teach norms of civic and therefore civil behavior. And what I mean by this are actually quite simple norms, like don't be a jerk, or even somewhat more complicated, don't abuse the rights that you have. Now, the question is, how do you teach those norms? Now, one possibility is that you model appropriate behavior. So in the face of a kid who is a jerk towards a teacher, the teacher can refrain from being a jerk in response. That's some of the insults to teachers' cases, or insults to the school principals' cases. You can adopt non-coercive responses, engage the student with it, and explain why the behavior is jerky. But you might think that sometimes both modeling and non-coercive responses are inadequate, particularly with respect to a kid who is already behaving like a jerk. And so it seems to me there's some role there should be some role in the overall scheme of things for some degree of coercion in response to jerkiness or abuses of what might be fairly characterized as rights. Second dimension of this is that, and this is associated with the cultural wars dimension, public schools also have to maintain popular support in the long run. And what that means is that it may be important that they avoid controversies with politically important constituencies. And because of that institutional role, they're different in that respect from politicians. We don't care whether politicians lose support from important constituencies. All that happens in our civic order is that those politicians lose their jobs, and who cares about that, except for the politicians. But we should worry if public schools lose support from important constituencies. Okay, so given these two things, the role in educating for civic participation and the possible inadequacy of non-coercive responses to what I've been calling jerkiness and the need to maintain popular political support, there are a couple of perspectives that we could adopt. One is to adapt external constitutional norms, those applicable elsewhere, to the special circumstances of schools. So in this view, material disruption might not be the right standard for hate speech or bullying speech because of the school's role in teaching civility norms. And here the contrast is with Cohen in California, which denies the government in this external capacity the power to regulate speech in the service of civility norms. That's the best case for what the state did in Cohen in California is regulation in the service of civility. And the court properly says you can't do that. But maybe you can do that in the school context. Alternatively, you could develop the external or general constitutional rules in a more complex, context-sensitive way. So in Fraser, you treat the immaturity of the audience and the captive audience aspects of the problem as instances of general norms, which is sort of what happens in FCC versus Pacifica. There are kids in the car, they're sort of captive. So the kids, they're immature, and they're in the car, so they're sort of captive, and so the regulatory authority is okay. I want to suggest a couple of things. First, and this is explicit at the end of Professor Ross's book, of course, we do want to ensure that teachers and administrators are sensitive to constitutional values. In a fair number of the case studies, I think, the law as applied in the courts seems okay. In a fair number of the examples, the students who challenge the action win when they get to court. But the concern is that the cases should never have gotten to the courts. And they get there because administrators aren't sensitive to, or perhaps even aware of, relevant constitutional norms. And so what in this dimension, you want to develop a good program to educate teachers and administrators. That won't be easy, at least in my view, particularly if the law is, in fact, institutionally sensitive, so that just importing what I've called external norms into the school context it wouldn't be adequate, but qualifying the thing for the school context might lead administrators to say, actually, no, here, there are lots of things we can do, and they'll push the bounds, as Professor Ross suggests. Second possibility is, and I'm actually quite attracted to this, that you have a legal standard denying liability for actions taken in the good faith belief, which will incorporate some notion of knowledge of the relevant law, taken in the good faith belief that the actions will advance educational goals, where those goals are defined to include both the express curriculum, English, math, and so on, and the goal of promoting helping students to grow into becoming good citizens over time. Just as a footnote on this, you might want to distinguish here between a prospective declaration that the action shouldn't be taken again with immunity from damages for the action, but some notion of good faith promotion of educational goals seems to me a useful way of thinking about the problem. So that's it for me.
I'll respond really briefly just to say that at the end of my book, I do, in fact, make some proposals about positive things that schools can do, that educators can do, and also that citizens can do to help sensitize their local school districts to preferences for respecting civil liberties before there's an incident that causes the administrators and the school board to dig in. So I agree with a lot of what the commentators have said about things that can be done, and I just didn't reach that in my preliminary remarks, and I really appreciate the very careful and thoughtful reading that all three of you did.
My question is to Professor Ross, and I think it's Professor Gregory who seems to set a very low bar in terms of how schools not only can censor but even prevent speech. It's not just speech that might be disruptive, but speech that might not be conducive to a comfortable environment for the students to learn. I mean, that seems like a very low bar to me, and also, I don't think the purpose of our First Amendment, I think it's an inalienable right. I don't think our First Amendment is predicated on some utilitarian value that it somehow makes things comfortable for everybody or serves as a lesson in civics. Thank you.
I'm not sure where the question left the comment, but just very briefly, I think the two statements are not incompatible. I didn't see Professor Gregory's bar as being all that low, but I agree with you that the First Amendment is not utilitarian, and in fact, Tinker itself talks about our disputatious society and discomfort, and yet some schools say, well, our legitimate pedagogical reason for silencing speech is it's too controversial and uncomfortable. That is not acceptable. But I propose something that is still a bit inchoate called an infringement matrix, which is sort of somewhere between where you are and what Professor Gregory suggests, which is where the disruption standard in Tinker is really supposed to be about the school as a whole, an impact on the whole environment. But sometimes individuals are so harassed and targeted in a repeated way, where it's intrusive and really in your face and inescapable. And that might trigger some of those fight or flight things, as well as some more things that we're more comfortable with in the law traditionally, so that we could say for that student, and this has been implied, in fact, to students with special needs by Judge Weinstein, it rises to a level where the student can no longer access education, like the Davis versus Monroe standard. And so there we say it's not an instrumental understanding of speech. The speech right is clear, but it is subject to some limitations if used too irresponsibly, so that in a school where students have no choice but to be there and can't walk away from the speaker during the school day, there might be some way of protecting them consistent with free speech norms.
Okay, we're almost out of time, but one or two more questions?
Up front.
Professor Tushnet, you discussed an idea about legal responsibility of the administrators and your idea of kind of a good faith mistake that they might make. And it seems to me that that opens up a huge can of worms, and it really shifts the burden of them in preparing themselves beforehand, before they even become administrators, to know very well that these constitutional principles, however they may be defined, are there, right? And I want to analogize that to the same idea that was done, I think, in the mid-'90s about Fourth Amendment issues, specifically Wren, where you give the police a good faith exception to allowing otherwise illegal searches and seizures to happen. And I just foresee a slippery slope where they could always hide behind, well, you know, our goals were, you know, honorable and, you know, mea culpa, but, you know, too bad. Would you like to respond to that?
Yeah, so I agree with the analogy. The tradition from which I'm talking is it's sort of an old-fashioned, now 100 years old progressive tradition in which one of the goals is professionalization of street-level administrators, including police officers and teachers and administrators. So, and one component of becoming a professional of that sort is learning about the Constitution. And so, in principle, I think the good faith behavior by police officers is actually fine. The problem is we don't have an adequate system of ensuring that they are actually aware of what the Constitution says they should do. And similarly, it may well be true that education of educators is inadequate for them to become what, in my view, would be true professionals.
Thanks, everyone, for coming today and joining us for our first book talk. I hope you are able to join us for our other talks in our spring series. Just a gentle reminder, we have, I see, quite a few copies of the book on the back table, courtesy of the Coop. So let's thank our panel today for a wonderful presentation.